For those of you already who are familiar with all the chaos that's going on with the P. Diddy lawsuits and criminal charges and everything that's going on with the P. Diddy stuff, well, there is just another celebrity that was just brought into a lawsuit as well. This is a little-known celebrity by the name of Jay-Z. Jay-Z, also known as Sean Carter, was just named in a lawsuit for allegedly victimizing a 13-year-old girl in a very sexual way. So he is now being sued in this lawsuit. So Jay-Z went and he hired an attorney, and he hired a very good attorney, not just a very good attorney, but one of the best attorneys in the country, a fellow by the name of Alex Spyro. Now, some of you may be familiar already with Alex Spyro. Alex Spyro represented Alec Baldwin, and along with other celebrities and high net worth individuals who get into some sort of trouble or are sued, they go and they hire Alex Spyro because he's one of the best attorneys in the country. So Alex Spyro actually, as you'll recall, got a dismissal on Alec Baldwin's case in the middle of trial because he found out that there was some serious Brady and discovery violations there, but that was a different case. So now Jay-Z has hired Alex Spyro, and Alex Spyro now is requesting from the judge that the name of this alleged victim who is suing Jay-Z for this sexual conduct that he forced her into. So he is requesting the name be, let the name be known. You have to let the person who you're suing know who's suing you. So this lawsuit was filed by the plaintiff named Jane Doe. Now, who is this real Jane Doe? Who is this Jane Doe? And does Jay-Z have the right to know who this person is? And when do we apply certain anonymity for plaintiffs in this position? That's exactly what we're going to be talking about today. And this is what they're fighting about as we speak. These are the motions and responses that they're arguing about. But just to kind of set the stage for what led up to this, what led up is the following. The person representing the plaintiff, the alleged victim in this case, is a fellow by the name of Anthony Busby. Okay, so Anthony Busby is the attorney representing the victim in this case. Now, what happened here is that he sent a demand letter. And this is very common in personal injury, plaintiff personal injury. When you have a case like this, a lot of times you won't just go and file the lawsuit in court. You'll send a demand letter. You'll send a letter saying, hey, let's avoid going to court. Let's just mediate. Let's negotiate. And therefore, we don't have to go through the 2.5-year process and start deposing everybody and getting discovery done and going through trials. Let's not do that. Let's just talk. Let's figure out a reasonable settlement, and let's just settle the case without having to go through the whole circus of litigation. This is very common. Now, it seems that this was the letter that was sent to Jay-Z by Anthony Busby. Now, what then happened was that there was a lawsuit that was filed by a John Doe. Okay, so now here we have a Jane Doe who is claiming that Jay-Z committed some serious sexual crime on her and is requesting money damages. And now you had a lawsuit filed, an extortion lawsuit filed against Anthony Busby, claiming that this is all one big extortion. And this is a pattern. This is what Anthony Busby does. He targets high net individuals, threatens them with these type of lawsuits, which can destroy their reputation. And that way he extorts money from them in the guise of a legitimate lawsuit. So Jay-Z goes and under the name of a John Doe, we don't know it's definitely Jay-Z or not, but he files this lawsuit as John Doe against Anthony Busby for extortion. Well, then what happens is Anthony Busby goes and files a formal lawsuit. So no more demand letters, no more negotiating. Obviously, you don't want to negotiate. Now I'm going to file a real lawsuit. And he names P. Diddy as well as Jay-Z in this lawsuit for allegedly this conduct, this sexual unwanted conduct with a minor that allegedly Jay-Z did on this victim. Okay, so he filed it as Jane Doe. So then what happens is that Alex Spyro, the attorney for Jay-Z, filed a request that this case either be dismissed, because one of the rules is that you have to name the plaintiff. You can't just hide behind anonymity and pretend that we don't know who the plaintiff is and just go through discovery. You can't do that. So in general, okay, there are some exceptions, but in general, you can't just file it on behalf of Jane Doe. You have to actually name the plaintiff. So Alex Spyro is saying either dismiss this case or you got to name who this victim is. And once you name the victim, then we're going to be able to do our discovery and figure out who this person is, if this person ever existed, if this person ever met Jay-Z. So that's what's going on now. And the argument back by the plaintiff is that no, we don't have to turn over this person's name because in these circumstances, these special circumstances, we do not have to turn over the name of the plaintiff. And even if we are going to turn it over, it's not going to be to the public. It's just going to be a confidential disclosure to the defense attorney, who's not allowed to, like, have some sort of gag order, not allowed to talk to the public about who this alleged victim is. So those are the two requests by the plaintiff. Either we're not turning it over, we're not going to say who this person is, this victim, or even if we are, it has to be confidential in the defense, and only you're allowed to know it. So this is what they're arguing about in the court right now. So let's go through the response by Alex Spyro. Now, I think in this specific area, the law is pretty much the same. There's a number of factors that you have to go through in order to see whether a person gets to retain his anonymity when he is or she is filing a lawsuit for money damages against the defendant. There's a number of factors that a judge has to go through, and that's really, they both agree on the factors. The question is when the judge is actually supposed to be weighing these factors, how the judge is supposed to weigh it, and what the ultimate determination is supposed to be. So here, there's a general consensus, which is rare, but here there's a general consensus between the plaintiff and the defendant in this case about what the governing law is. The question is, how do you apply those factors? How do you analyze those factors? So what we're going to do here today is we're going to pull up the response by Alex Spyro, and he has a certain way of writing, and he really, it's a certain style, and I appreciate it. I like it because it's definitely got some snark in there, and some of you know me that I like some snarky responses when you're writing. And he takes some shots at Anthony Busby, and along that, he also does a very, very good legal analysis of the issues. So without taking sides, we're just going to go through his response. And obviously, you can imagine that Anthony Busby is going to argue about some of the factors, how you analyze them. But we're going to be taking a look at Alex Spyro's response and why he's requesting that the name of this alleged victim be turned over and be made public. So here we go. I'm going to pull it up, and we're not going to go through the entire 29-page document because that's how these big city firms do it. They don't just file something that's 2 pages long. Usually it's usually going to be a long document that has a lot of extra information because they get the bill by the hour. Okay, we're not going to get into that, but we're going to be cutting through some of the parts and just concentrating on the more important parts of the argument. So let's pull it up right here. This is his response. We're cutting into the middle of here where it starts. Defendant Sean Carter, aka Jay-Z, has built an impeccable reputation. He has never been accused of, let alone engaged in, any sexual misconduct. Until today, when plaintiff, in an amended complaint filed by attorney Anthony Busby, has leveled baseless allegations and accused Mr. Carter of despicable acts while hiding behind the pseudonym Jane Doe. These claims are not about justice for victims, nor are they about giving victims of sexual violence a voice. Instead, they are merely the next chapter in Anthony Busby's sprawling extortion saga, a saga whose aim is base and measured in dollars. He doesn't hold back the punches, Alex Spyro. Busby has devoted himself to the business of extracting large settlements from celebrities, high net worth individuals, and businesses with any public ties to Sean Combs, aka P. Diddy, etc., following his indictment for sex crimes in September 2024. References to justice or sunlight serve only as window dressing. Make no mistake, this case is about retaliating against the rare target who would not pay. So he's saying Jay-Z here is a rare target because he's not just going to turn over and say, okay, I don't want the public humiliation of these type of lawsuits being filed, so I'll pay you all these millions of dollars, because if I try to fight this and all this nonsense is going to come out, people, it's going to really tarnish my reputation and make me lose perhaps millions of dollars. So I'll just pay you. And that's what generally At least the case that Alex Spyro was making. That's what generally these celebrities do. They just pay the money because it's not worth it for them to go through this whole process. But guess what? JC said, I'm not doing that. I'm going to fight this because it's not true. And I'm not just going to pay over money because I have it. Attorney Boosby has a history of targeting celebrities by making false allegations of misconduct, and Mr. Carter sought to expose Attorney Boosby's latest extortion scheme in California lawsuit on November 18th, 2024, after receiving a demand letter from Attorney Boosby. So that's what we spoke about. That was the lawsuit that followed this demand letter by Attorney Boosby. Okay, let's keep going down. Mr. Carter should not have to defend himself in the brightest of spotlights against an accuser who hides in complete darkness while leveling allegations that describe the purported acts occurring in the plain sight of witnesses who could refute the plaintiff's claims if only her identity was revealed. So they're claiming, hey, this was done with a bunch of witnesses watching. Okay, well, who are the witnesses? Who's the plaintiff? We have to know who the plaintiff is so we can talk to as soon as we know who the plaintiff is, we can ask the witnesses, hey, remember this plaintiff? Was Jay-Z doing anything? And then case closed, right? So don't say that now he has to defend himself in the brightest of spotlights while you get to keep the accuser gets to hide in complete darkness. Let's continue. Attorney Boosby has for months taken to traditional and social media to describe how he planned to target celebrities in connection with these allegations, and he has now issued multiple social media posts about this action. Traditional media sources have somehow been reporting, with Boosby's express endorsement on social media, that Mr. Carter is the target of Boosby's allegations. Thus, the plaintiff, through her counsel, has acted quite unlike a party who wants to minimize the amount of public attention on this matter. Don't pretend that you want to minimize the attention to this matter. You're the one blowing up on social media. You're going on all these shows. You're letting everybody know about what's going on here. So don't pretend that you are just want the quiet darkness of anonymity. Give me a break. Thus, the plaintiff, through her counsel, has acted quite unlike a party who wants to minimize the amount of public attention on this matter. Instead, Boosby has attempted to leverage public scrutiny to taint a potential jury pool and put pressure on Mr. Carter to settle this meritless case. Continuing, Mr. Carter deserves to know the identity of the person who is effectively accusing him in sensationalized publicity hunting fashion of criminal conduct, demanding massive financial compensation, and tarnishing a reputation earned over decades. The court has recognized the nearly identical claims brought by other plaintiffs represented by Attorney Boosby do not meet the criteria to proceed anonymously. So this is going to be a very strong argument that he makes throughout the brief, is that this is not the first of its kind. There's a number of other plaintiffs here who have sued P. Diddy, and they've had to say their names, meaning judges have gone through the same motions that we're going through right now, and a lot of the other judges, almost all of them, have said that you've got to release the name of the alleged victims. Well, guess what? If everybody else is doing it, then you should also do a judge. So even though this is a new judge, a different judge on this case, still, judge, you should what the other judges have done in similar cases where they required, and again, represented by Attorney Boosby for very, very similar allegations. And nevertheless, those other judges have said that this information, the names of the alleged victims, have to be turned over, have to be made public. Here, the balance of equities afford all the more reason why this plaintiff should be proceeding under her true name if she wishes to proceed at all. Okay, going through background, we spoke about the background. And here we go again. In at least 2 cases filed by Attorney Boosby with this declaration, other courts in this district have already denied his baseless motions to proceed anonymously for failure to meet the burden to show each plaintiff was entitled to the exceptional remedy of anonymity. So we're going to see that this is an exceptional remedy. There are certain times, there are certain cases, if you meet the factors and if you meet the burden, then there is an exceptional remedy where certain plaintiffs get to stay anonymous. But 2 other cases that are filed by Attorney Boosby, guess what? It hasn't happened. The judges have not agreed. There is every indication that this lawsuit is not truly about plaintiff. This is a shot that he's taking the entire time throughout this brief, is that this has nothing to do with this poor victim. This is Boosby using the victim for his own agenda. to get into the spotlight, to get onto social media, get all the interviews, whatever, for his own personal reasons. That's part of the argument that he's going to be making here. There is every indication that this lawsuit is not truly about plaintiff, but about Attorney Boosby's larger unsavory agenda. Despite plaintiff's request to proceed anonymously, plaintiff's counsel is doing everything to draw widespread attention to her. So again, you're seeing this contradiction. You're claiming, oh, we need to keep this anonymous. We can't let this get out. Well, then why are you blasting this all over social media? The same day the amended complaint was filed and naming Mr. Carter, Attorney Boosby posted on Instagram and Twitter, prominently featuring himself, addressing the amended complaint and making clear this is not about his clients, but is about his personal spat with Mr. Carter. And then they attach this Instagram post or Twitter post that Anthony Boosby, made. All right, let's continue. These tactics are designed to silence the other extortion victims who, like Mr. Carter, have been targeted by Attorney Boosby, not based on their perceived culpability, but the depth of their pockets. That's such a great line. These tactics are designed to silence what he calls the extortion victims. So he's kind of flipping the victimhood, right? Everybody understands, the victim here is the person who's been allegedly sexually victimized in the complaint. He's saying, no, these are victims who are trying to be extorted by Attorney Boosby. Attorney Boosby's tactics send a clear message. Any individual who resists extortionate demands will face public retaliation through highly publicized lawsuits. This strategy is designed to silence other victims, meaning extortion victims, of Attorney Boosby's extortion while creating media spectacles to amplify unfounded claims and maximize monetary recoveries outside of court. That this plaintiff is suing only now after Attorney Boosby has been left stinging from personal rebukes and defeats supplies positive proof of how he elevates his own interests above those of clients. So again, he's not holding back any punches. He is really taking shots at Anthony Boosby. All right, now let's go on a little bit more. Procedural history. On November 6, 2024, before Mr. Carter was named, the court provisionally granted the plaintiff's motion to proceed under a pseudonym in this case. So let's understand that right now there was an order where the court granted the plaintiff's motion to proceed under a pseudonym. So there was an initial motion that was brought by the plaintiff and it was granted. And therefore, the plaintiff is proceeding under the name Jane Doe. So he has to talk about this. At that time, the only named individual was Mr. Combs, who was indicted and had a flood of allegations leveled at him by myriad plaintiffs at the same time. In that order, the court clarified that at the time it was entered, again, at that time it was just against P. Diddy. It wasn't against Jay-Z. So at that time it was entered, this is what the court said: the balance of these interests may shift as this matter proceeds, and defendants deserve to be heard on this issue. So if the defendants want to bring up this issue again, no problem at all. That's what the judge is saying. We're going to start off like this with Jane Doe, not knowing who the victim is. As long as P. Diddy's here and there's all these type of claims coming out against him, okay? But things can change. And the judge right away is leaving that open. Things can change, and the defendants could be heard on this issue. Well, now their defendants are being asked to be heard on this issue. So on December 8th, 2024, plaintiff's counsel filed an amended complaint naming Mr. Carter. So now they named Jay-Z on December 8th, an upstanding public figure who has never been accused of anything like this in his life. A very strong statement. And if it's true, it's very compelling. If Jay-Z never had any sort of issues, all of a sudden, years and years and years of being in the spotlight and as a celebrity and all the opportunity in the world, and all of a sudden now Anthony Boosby is trying to jeopardize on this, what's going on with P. Diddy, and try to drag Jay-Z in and try to, from monetary benefit, then it looks a little bit more suspect. Okay. So let's continue down. And now we'll get into the legal standard, talks about the legal standard. And here we go. Okay. So this is what I was talking about, that there is a list of factors that the judge has to consider before determining whether the plaintiff can proceed under Jane Doe. The Second Circuit which is the circuit that's relevant here. The Second Circuit has enumerated a non-exhaustive list of factors. What does non-exhaustive list of factors mean? It means that this is a nice list, but there can definitely be some more other considerations also thought about. So this is just a non-exhaustive. This is just like, here, these are a few factors that you should consider, but you can definitely consider other factors as well. So this is a non-exhaustive list of factors to determine whether a plaintiff's interest in an anonymity outweighs the interest of both the public and the defendant. So that is the balancing act that has to be done here. The judge has to weigh the plaintiff's interest in anonymity, and also at the same time, on the other side of the scale, has to weigh the interest in the public. There's always a public interest in this case. In any case, there's a public interest, and the interest of the defendant. So that's what the judge has to weigh: the plaintiff's interest of an anonymity over the interests of the public and the defendant. Okay, so these are the non-exhaustive factors. These factors are the following: whether the litigation involves matters that are highly sensitive and of a personal nature. Well, you can definitely be sure that one's going to be met here in this case. Number 2, whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties. So is there any sort of risk of physical harm or mental harm to the plaintiff if the plaintiff's name gets out there, or critically to more innocent non-parties? Some innocent person may suffer some damage now, some physical damage. That's also something that you have to consider. Number 3, whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. So this is what they refer to as other harms. Are there any other harms that could happen to the plaintiff if you disclose their identity? Number 4, whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age. So age is going to be a very important part. How old the victim is. If the victim is a very young child, then obviously that's going to affect her. If she's 18 and she's in college, these things will affect her. If she's 35, it's a little bit different story. Okay, well, we'll get to that. Number 5, whether the suit is challenging the actions of the government or that of private parties, whether the defendant is prejudiced by allowing the plaintiffs to press her claims anonymously, whether the nature of that prejudice. So is it going to prejudice the defendant by allowing the plaintiff to continue with her being Jane Doe, but them not knowing who this person is? Is that going to prejudice the defendant? And if the nature of that prejudice differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. Number 7, whether the plaintiff's identity has thus far been kept confidential. So if the plaintiff is out there saying all the time on news stations, hey, this is who I am, this is what happened, but for the purposes of the lawsuit, we're going to keep it as Jane Doe, well, then obviously there's more reason to disclose the name because the person obviously doesn't care that much. Whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity, whether because of the purely legal nature of the issues presented or otherwise, there is an atypical weak public interest in knowing the litigants' identities, and number 10, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So let's continue. A district court is not required to discuss every factor or use any particular formulation, provided that it balances the interest at stake. So there's no formula here. There's no like, okay, let's see, 8 will score it at 3, and 9 will score it at 5, and 10 will score it at. That's not the way this works. Okay, this is just ideas. These are factors that you should consider. The district court should consider. They're not required to discuss every factor. All they have to do is do some sort of balancing act using some sort of factors. And these are a good idea, a good place to start about weighing these factors. But the point is that you got to balance the interest at stake. That's all. That's all you got to do. Now, of course, since these are good lawyers, they're going to go through these factors and see whether these factors are relevant in this case. Plaintiff, remember the plaintiff here, must bear the burden of rebutting the presumption of open records and establishing that the balance of factors weigh in favor of proceeding pseudonymously. So the plaintiff is the one that has to rebut the presumption. The presumption is that we want things to be open. We want courts to be open. That's why things should be videotaped and live streamed. We want these proceedings to be open to the public. We want people to know what's going on, who's suing who. That's a very strong interest. So the plaintiff is the one that has to bear the burden of rebutting that presumption. Okay. So we're going to get into some of the argument here. So now this is Alex Spyro going through the factors. So highly sensitive and personal allegations. Well, yeah, plaintiff's allegations as pleaded are highly sensitive and personal in that they describe a sexual assault, to be sure, one that Mr. Carter was not involved in. Okay, so they're just saying, okay, by the way, even though your complaint says this, he never did it. But okay, the as pled, it's a highly sensitive personal allegation. There's no way around that, but they have to agree to that. However, allegations of sexual assault by themselves are not sufficient to entitle a plaintiff to proceed under a pseudonym, meaning that just to say, if this is the only factor that you have, that's not enough. That's not enough to say, okay, well, because it's so sensitive and it has to do with these sexual assaults, so that automatically qualifies you for, anonymity. No, that's not the way it works. I mean, it's one of the factors. That's true, but it's not the only determining factor. So that's what he shows from the case law. Okay, so that's the first one. There's no real around that. You have to acknowledge that that is what the complaint is about, but that's not dispositive. So you got to talk about the other factors. Risk of harm to plaintiff or third parties. The second factor is whether identification poses a risk of retaliatory physical or mental harm to the plaintiff, or even more critically, to innocent non-parties. That was another one of the factors that we mentioned. The plaintiff offers no evidence of any actual risk of harm to her whatsoever. So here, the plaintiff is the one that made the request, the initial motion to keep everything anonymous. Well, you have to, as the plaintiff, the burden's on you, as the case law just said. You've got to show that there's going to be harm to the plaintiff or third parties. So here, does the plaintiff does the plaintiff offer any sort of evidence showing that there's going to be a risk of harm to the plaintiff if her name gets out there? So he argues, this is Alex Spyro's arguing on behalf of Jay-Z, that no, plaintiff offers no evidence of any actual risk of harm to her whatsoever. Instead, Attorney Boosby makes the speculative and conclusory allegations that appear to pertain primarily to other clients of her counsel, not to her. So there's all he argues is that there's other clients that may be affected. There's other clients, but nothing to this specific victim, this specific Jane Doe. There is no allegation that there's going to be some sort of risk of harm to her. Now, again, third parties are also to be considered, but this is the first point that he's making. Courts have routinely rejected attempts by litigants to shoehorn themselves into the narrow exception to the names disclosed rule through such conclusory secondhand declarations. So this is just conclusory. He's just making, they're probably at risk or something like that. So it's speculative and it's conclusory. Mr. Carter is a well-regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, intend to litigate this case through the court system rather than social media. Okay, so that's just another attack that he took. And I go again. Plaintiff's counsel stresses that other alleged victims he represents have stated that Mr. Combs made threats of violence against them or against the client's family members if the client disclosed to anyone the facts of the sexual assaults. So here's what the plaintiff counsel is stressing. The plaintiff counsel is stressing that these third parties, these other victims, which again, something that you have to consider, what type of risk of harm is there to these other parties? So that these other victims, these other third parties, have stated that Mr. Combs made threats of violence against them or their family if this ever gets out. So that's the allegations. The victims are saying that, the families are saying that again, this is the plaintiff's counsel's assertions, that this is what his declarations. So this is Boosby's declarations that, the family has said that they're scared that if any of these details get out, then Mr. Combs is going to inflict harm on them or cause to be inflicted harm on them. But there is certainly no allegation that Carter ever threatened to harm plaintiff, nor could he, as he has no idea who she is. So he's saying, okay, what does that have to do with Carter? What does that have to do with Jay-Z? Jay-Z's never threatened anybody. And he never said, plaintiff's counsel never said that Jay-Z said to these families that if you ever, or to the person, or the other victims or the other families, that if you ever say anything, I'm going to harm you or cause harm to be done to you. So what do you want from Carter? What do you want from us? So that's the argument. Now, again, that's not the only limiting factor. You don't just look at, what the harm that Jay-Z could do. It's any harm that can be caused to these people if this word gets out. So it's not just harm that Carter specifically will inflict on them. It's harm in general that can happen to them. So not the strongest argument, an argument nevertheless. Plaintiff's counsel asserts, without offering any evidence, that plaintiff would certainly experience mental harm. So now he's moving on to the mental harm part. If she is forced to reveal her identity to the public. So she's going to suffer mental harm. Okay? So first of all, he cites a case that in this context, public humiliation is not enough. Just public humiliation, that's not considered mental harm. And actually, what is considered mental harm? We're going to see in a second. But first, he says, nor is it sufficient for plaintiff to put forth a generalized argument that revealing the identity of a victim of sexual assault would further victimize her. That's not enough. Again, this is not considered mental harm. Well, what is considered mental harm? Well, here's an example. One court in this circuit allowed a plaintiff to proceed anonymously where she submitted evidence from a medical professional. So this is not from a lawyer, not from her lawyer saying, she's going to for mental harm. No, this is actually a medical professional who submitted evidence who predicted that requiring disclosure of her name would cause psychological and emotional pain so intense that it would threaten her stability, her safety, and even her life. Okay, now we're talking about real mental health scares. Okay, that's mental damage. That's mental health problems. So that is something that would rise to that level where you keep the person anonymous. But there's been no evidence of that. Even where such medical evidence is present, other factors may still tip the balance against permitting a plaintiff to proceed anonymously. So this is quoting a different case, Rapp. So I don't know if it's directly on point to what this other case, Doe versus Smith, stood for, but still they're saying if there is such medical evidence that there could be some sort of mental harm, that again is not dispositive in of itself, that the person can then proceed as Jane Doe. Okay, so, and then again, conclusory statements and speculation about mental harm to plaintiff is insufficient. So these are just conclusory statements made by the attorney who's representing the victim. So then the judge should not take any of that really too seriously at all. So that's another argument. Plaintiff's counsel has failed to provide any evidence, no statement from a mental health professional, no affidavit from plaintiff herself, nor any corroborating proof to support the bare claim that disclosing plaintiff's identity would harm her mental health. So mental health, you just haven't, the argument here is that they haven't shown any sort of evidence that there's going to be any sort of mental harm here at all. As plaintiff's counsel has repeatedly claimed, sunlight is the best disinfectant. This is what attorney Boosby has said in one of his posts. Sunlight is the best disinfectant, meaning let's get things out in the open. Well, guess what? That's what we also want. Mr. Carter is entitled to investigate the plaintiff's background and challenge her allegations and her credibility in order to defend himself against these false accusations. Moreover, media outlets have no right to publish stories about this case. Okay, so now moving on to the other harm. Now, he did, I think, make a strong argument for mental harm, but what about the other argument about the physical harm? Even though he said, you're right, there's no physical danger from Carter himself, there's no allegations of that, but still, once the name gets out there, and P. Diddy was allegedly part of it, and he is not going to be happy with that information coming out there, then definitely that's harm that the judge should consider before granting this request by the defense to release the name. So that part, I don't think he did as well or addressed as well as he did the mental harm aspect. Okay, but let's move on to now the next part, other harm. Plaintiff does not argue that she faces other severe harms for which the second factor does not account. Okay, so now he goes through this other factor, and since there's been no allegation of other harm, so then this is in favor of the defendant. Now, continuing, plaintiff's age. Remember, that was one of the factors. Plaintiff is not especially vulnerable, particularly in light of her age. Plaintiff is an adult now, 37 years old. So you're right, when this happened, the allegations are that she was 13 years old. But now, according to the years, now she's going to be 37. So if she's 37, well, then that's a whole different story. It's not like she's 17, 18, and, that's much younger. She's 37. So talking about age, that should not weigh against that should not weigh for anonymity. It should weigh against anonymity. Okay, then we have some other ones. Prejudice to defendants. Okay, and what about the prejudice to defendants? What type of prejudice will Carter Sean Carter suffer, Jay-Z suffer, if the name is not publicly disclosed? Well, here we go. Relevant to this inquiry is whether defendants would experience difficulties in conducting discovery, the reputational damage, and the fundamental fairness of proceeding anonymously. So these are the different elements of this factor: the difficulties in conducting discovery, reputational damage, and fundamental fairness. So, as a good attorney is, he's going to attack all of them. And first, he's going to start off. Mr. Carter needs to know the plaintiff's identity to depose her. Right? We need to take her deposition. We need to find out everything that she's saying, everything that led up to the occasion, everything that led up to the incident. We need to know. We need to know what happened after. I mean, we gotta be able to depose her. We have to be able to talk to her. And if we don't know who she is, then how are we supposed to be able to depose her? And we also have to prepare to depose her. So if we don't know who she is, so we can't start looking up other information about her so we can use it to ask her questions about. If we don't know who she is, we can't possibly prepare for that deposition. So obviously there's going to be a lot of prejudice against the defendant if they cannot take the deposition of the alleged victim in this case and not take it effectively. So that is going to weigh against the plaintiff also. Plaintiff is bringing a lawsuit about an incident that allegedly occurred more than 24 years ago, which may be difficult to defend given the passage of time, even with information about plaintiff's identity, hamstringing Mr. Carter by preventing him from even knowing where to begin his investigation. This happened a long time ago. We need all the information that we can get in order to really defend this case. Plaintiff's counsel confidentially disclosing plaintiff's name. So this was another suggestion that, okay, well, we'll just give you the information. We'll give the defendant the information and that's it. No, plaintiff's counsel confidentially disclosing plaintiff's name to defense counsel would not obviate the potential prejudice. Highly publicized cases can cause unknown witnesses to surface, right? If you have a highly publicized case and everybody's reading about it and hearing about it and watching brother counsel about it, well, then someone will say, hey, I know something about that case, and they'll reach out and they'll contact the defense. We've seen this happen many, many times in many high-profile cases where other witnesses will get involved because they've seen the coverage. So that's important in these highly publicized cases. However, if plaintiff's name is kept from the public, information about only one side may thus come to light. So you're only going to hear information that's going to benefit the plaintiff because you're just going to be hearing about Jay-Z around this time. Where was he? And then other people start coming out of the woodwork. But if you don't hear anything about the plaintiff, so then it's only going to be one-sided against Jay-Z. So it's got to be fair, right? Fair is fair. That's actually a quote that he actually says in this brief. I just glossed over, but he does say fair is fair. And if it's going to be fair for one side, it's got to be fair for the other side. In particular, persons with information about plaintiff or her allegations that would be helpful to the defense likely would have no way of knowing to come forward. This asymmetry between the parties not only would prejudice defendants, but would hinder the judicial interest in accurate fact-finding and fair adjudication. So, yes, definitely a very strong prejudice against the defendant in this case if you don't give them the name. Indeed, the potential prejudice to Mr. Carter with respect to discovery is inseparable from the potential prejudice to his reputation and fundamental fairness. So that's the other two categories. Remember, they went into reputation, fundamental fairness, and that it's inseparable from the prejudice that's going to happen to his reputation, fundamental fairness, if he doesn't know who this person's name is, and therefore cannot conduct discovery appropriately, and therefore not save his name. So then there's some other factors that they argue for here. Here's another one. Plaintiff contends that the public interest favors granting her motion to proceed under a pseudonym so that victims of sexual assault will not be deterred from vindicating their rights. Now, this is a common argument that you're going to make in these type of cases, right? The plaintiff is going to contend that, look, the public interest here is to grant the motion to keep everything anonymous, because then other victims of sexual assault will come forward and they won't be deterred because we're keeping everyone's name private. However, as noted above, a number of other alleged victims have already sued Combs in their own names in this district. But you can't argue that in this case, Alex Spyro argues, because there's been already a number of victims that were happy to have their names spelled out in the complaint. So you can't say, oh, this is going to prevent other people from coming forward. We have a whole bunch of lawsuits already with people coming forward, no problem. So that's his argument, that they should be able to say who the name is. Okay, so that is a number of the factors that they argue should be in the favor of full disclosure. Let Jay-Z know who this alleged victim is, and therefore stop hiding behind this cape of anonymity. Come out like a real woman, and let's fight it out if you're really serious about what you're saying and you really believe it, and you're not just making it up for money, and this isn't just your attorney trying to get money out of a quick lawsuit. Well, then let's go. Let's have it out. And that is what Alex Spyro's argument is. Now, ultimately, is this going to be granted or not? Well, we already know in a lot of the other cases it was granted, meaning that these people had to say their names. So I think that there's a pretty good chance that this judge is going to follow what the other judges did. The same way the other judges allowed this name to come out, all the names to come out, well, then there's probably a very strong case for the judge to follow along with what other judges have been doing. That's usually a very strong argument when you know that the other judges in your courthouse are allowing the names to come out. Then that's going to weigh in Jay-Z's favor here. So we'll eventually see what happens. There has been a letter for an expedited hearing. So the hearing, they're asking for the hearing to happen right away as soon as possible. So that may happen within a week, who knows? And then we'll get a decision on this, and then we'll all be able to hear who this alleged victim was. Well, that's going to be it for today. Please, if you haven't yet, subscribe, like, and we will see you next time.